Now to a ruling in the High Court which could mean that the requests you leave in your will can be ignored. A woman has been awarded £164,000 from her estranged mother's estate, despite clear instructions for the money to be donated to animal charities. Well, let's discuss this more with the barrister Alison Sky. Alison, good evening to you. How unusual is this?
It is unusual for an adult child, an independent adult child, to be given an award out of an estate, especially where the person who left the estate said that that was expressly what they didn't want to happen to their money.
Why do you think it has been ruled in this way then?
Well, in this particular instance, well, the Act itself provides that an adult child can make an application for provision under the will, but they have to be able to prove that the will doesn't make reasonable provision for their maintenance. And that's why normally an adult child can't prove or can't establish a claim, and that's because normally if they have their own income or have their own property, then they can't persuade the court that they need maintenance. In this particular instance, Mrs. Jackson's daughter was in very difficult financial circumstances. She didn't have a particularly high earning capacity. She was reliant on state benefits. So the court decided in this instance she did need maintenance. OK, so
where does that leave people who have expressed wishes? They have something specific that they want to include in their will, and the fear that it could be ignored?
Well, I'm not sure there's much that can be done. As I say, this was a specific set of circumstances, because the other circumstance that was unusual in this instance is that the other beneficiaries under the will were charities, and they were charities Mrs. Jackson didn't appear to have much connection with. So again, if there were other people that an individual wanted to give money to rather than one particular child, then the court is far less likely to make this type of order. So, for example, if there's 3 children and one child is left out, the court may well not make a decision in favour of that one child, because the estate, they're following the wishes of the person who left the will and giving it to the other 2. As I say, this is another significant issue in this case, is there wasn't another family member who'd been left money under the will.
Am I right in saying then, Alison, that the provision is there because I have 2 children, that my will might have been done when I only had 1 and it just hadn't been updated, and that needs to be taken into account?
That's one of the factors to take into account. There's a whole series of different set of categories of individuals. If they haven't been provided for a will, Parliament has expressly provided that the court can, in specific circumstances, diverge from what a person has said in their will. So it is a very high threshold test a person would need to meet. And one would usually advise an individual, if you don't specifically want to give to a child, is a good example, but another member of the family who would otherwise normally inherit, if you leave a letter with your will, that would be a good way of instructing and advising everybody that that's what you didn't want to happen. But the court does still have that residue power. And I think the difference is that a lot of people don't realise that when they leave a will. They think what they say in their will is what is going to be done.
Just finally, Alison, do you come across it a lot, families that have been at war and it's just not been sorted out before death?
Yes, it's very common. My advice always is to talk within the family about what you're doing and why. Quite often then people respect the decisions more. It's quite often when it's a surprise or a last-minute change in the will, or a difference, as I say, between children. That's obviously quite common. But yes, this is a very common issue we come across.
Alison Sky, barrister, thank you very much.
Thank you.